persons in the public who wish to comment in support of this appeal, they will have an opportunity to do so after. So if you are on Zoom, just go ahead and keep yourself muted. And when you hear me ask for anyone who wants to speak in support of the appeal, that can be a time that you can unmute and try to speak. Following that, there will be the county's case in chief, and then any members of the public or other affected parties or persons who wish to speak in support of the county's decision or in opposition to this appeal. So now that we've got that, and the appellant will have an opportunity for rebuttal at the end that I will limit to 15 minutes as well. So now that that's out of the way, Mr. Callahan, would you like to introduce this, or one of your members of your staff introduce this appeal, please?
Thank you, Mr. Granrath. I'll be glad to. Before I go there, by way of housekeeping, I left on the dais before you information we received from Winston and Cachet. It's their case number, Ponderay Ranch Owners Association response to the appellant's legal argument. And I'd like that entered in as an exhibit at this time.
HE 1000.
And I also have copies if anyone would like a copy. And the introduction is brief. This really is an appeal of my denial of a minor subdivision. We based the denial based on our legal staff's opinion that this is one of those cases where the CC&Rs apply. Again, as you have heard us say before, we don't substitute our knowledge for our legal counsel's knowledge. And so this really comes down to a legal argument more than a planning one. And I'll talk a little bit more about that when it's my turn to talk. But for now, I think the only other introduction we really need before the appellant starts is just a reminder that testimony is set out by our Land Use and Development Code and is limited to the appellant, representatives of the department, my staff and myself, other affected persons, and that's defined in our code as any person or legal entity with a bona fide interest in real property that could be adversely affected. So with that, I believe it's fine to turn things over to the appellant.
All right. And I believe we have appellant's representative. I see two people here. We have, I believe, Ms. Fulgham is the appellant's representative. We also have a Sandy Younger here. Are you the appellant or another representative?
Another representative.
Okay.
If you don't mind, I'd like to go first.
Absolutely.
Thank you. So for the record, my name is Sandy Young. My address is 3906 North Schreiber Way, Coeur d'Alene. And I am a land use planner, and so I'm representing this from a land use planning standpoint. I have 24 years experience here in Kootenai County in planning. I worked for the Community Development Department for 10 years, and I've been in the private sector for 14. I'm here representing Doug Moshe tonight, who is Emerald Properties, LLC. And he proposes to develop his 20-acre rurally zoned property into 4 5-acre parcels. Those parcels would access directly onto Highway 54 to the north. Mr. Moshe went into the planning department probably about a year ago now to inquire as to the legality and the feasibility of doing a subdivision of this kind. And he's a reasonable man with a reasonable request, and he relied on some pretty reasonable rules that are clear and concise, as you know, in the zoning ordinance. And he was able to check all the boxes, as well as the department meeting with him. Mr. Callahan's staff reassured him that his application met the requirements of the minor subdivision ordinance, or that portion of the code that is the ordinance. He came to us and asked me to help him navigate the process just from a planning standpoint. And so that was my job, is to submit the paperwork and make sure that we could check all the blocks. I'm going to refer to the director's order of decision. And I'm sure you have that before you. It is dated August 10th, 2021. And being familiar with these, you know that there is the course of proceedings that outlines all of the steps that the applicant must take that meet code in order to be able to continue through the process. And if you look at each of those, every one of those was check, check, check. We did everything we needed to do, as well as the department meeting the deadlines they needed to meet. That moves us on to the third section, which is the applicable legal standards. Kootenai County Code lists different titles, same title, different chapters, and then, of course, the comprehensive plan. So really 2 documents guiding the decision on this subdivision, the comprehensive plan and the code. Then I went on as I was reading it. This is when I received it, the staff analysis. So we have 10 paragraphs in the staff analysis. None of them have anything to do with the legal standards that were just listed. Every single one of them refer back to the CC&Rs, that whether they govern this project or not will be a decision that's ultimately made, but that point will be taken by Michelle Fulgham when she comes to speak. So I don't want to address the legality of the CC&Rs. I simply want to point out that there is nothing in here that addresses the legal standards. So nothing to do with those, but everything to do with CC&Rs. And again, whether they apply or not is not what I want to discuss, but the fact that does the county even have the jurisdiction to use the CC&Rs in their decision-making process? There is no mention in the code, anywhere in the code, of CC&Rs, other than that they must be written if you're to have a subdivision in the major process recorded or approved at final, but nothing, of course, in the minor, and nothing that states you need to comply with CC&Rs. Even if they did apply and the county decided to enforce them, as it appears they have here, the department would have to hire 10 more people to go out and literally enforce CC&Rs. Then we get to, so that's staff analysis. Then we get to the conclusions of law. So here we have 13 items. Every single one of them, except for one, states that the applicant has provided sufficient information. The plat meets the requirements. The project and lots comply with the requirements of the chapter. The plat, the project, the lots are in compliance with the code. They meet the requirements of all agencies with jurisdiction. All negative environmental, social, economic impacts have been or will be mitigated. Services and facilities that serve the subdivision are available and adequate. Trails and sidewalks designed in such a manner. Sanitary restrictions lifted. Shared infrastructure. Conservation easements, even though they don't apply, and public notice. So the one item of all the conclusions of law, and I'm going to read it for the record because I think it's important to put it in the record. The subdivision design and proposed uses are compatible with existing homes, businesses, and neighborhoods, and with the natural characteristics of the area. The subdivision creates lots of reasonable utility and livability capable of being built upon without imposing an unreasonable burden on future owners. That comes straight from the code. Areas not suited for development have been designated as open space. The director states after that, while the applicant has demonstrated the subdivision creates lots of reasonable utility and livability, the design and the proposed residential uses are not compatible with the existing homes in the surrounding neighborhood with the natural characteristics of the area. It's zoned rural. These are 5-acre lots, as the code asks. The comp plan designation is country, which is specifically for this type of use. And when it's stated that it's not compatible with the surrounding neighborhood, I would like to point out, I've got a map exhibit that I'd like to submit. And if I might approach,
Please.
HB 1001. I'd like to illustrate.
that there are 163 5-acre parcels within a mile to 2 miles of the subject parcel, which you'll see outlined in blue. My statement would be that this proposal does, in fact, meet the intent of the area. It is compatible with the neighborhood. It's a residential use in a residential zone. And I will leave it at that unless you have any questions for me.
I have no questions for you at this time. Thank you.
Thank you.
Hi, go ahead.
Thank you. Good evening, Mr. Hearing Examiner. My name is Michelle Fulgham. I'm a land use attorney with Smith and Malik. And is that loud enough?
I don't think it's working. I think that you have to use the little, there's a,
Oh,
one of
use
those.
the button and she's got it. That should work.
You're hearing me okay back there? Okay.
I can hear you. So.
That's all that matters is that the hearing examiner can hear me. I'm a land use attorney representing the appellant in this matter. My address is 601 East Front, Suite 304, Coeur d'Alene Avenue, Coeur d'Alene, Idaho. And I agree with the director that this appeal focuses on a legal argument. It's clearly not a dispute over land use planning because this minor subdivision application complies with absolutely all of the land use planning criteria. As land use planner Sandy Young stated, that it fits the 5-acre requirements, all of the public agencies in favor, all of the infrastructure in favor, and with 163 5-acre lots within a 1 to 2 mile radius, it's compatible with the existing area and neighborhood. The sole basis, and the county really admits this in their decision, is the denial was based upon applying the CCNRs to this minor subdivision application and determining that the CCNRs apply, govern, and prohibit it. Number one, it's somewhat unusual. Typically the county stays out of these civil disputes and says, hey, that's a civil dispute between you and your HOA, and we're the government agency enforcing land use regulations, and we don't weigh in to these civil contract disputes, which is typically the appropriate determination. What our position is, and what the law in Idaho provides, is that when you have ambiguity, contradiction, discrepancy within CCNR documents, the interpretation that must govern that ambiguity, discrepancy, inconsistency is always in favor of the free use and development of land. It's the law in Idaho, and that's what should be applied here. There's inconsistencies, there's discrepancies, there's contradictions, and based on that ambiguity, the applicant should be entitled to the presumption under Idaho law of free use, unrestricted development of their property. You probably have it, but I want to just mark it separately as a hearing examiner exhibit. What are we up to? Number
1002, HE 1002.
May I approach?
Please.
The CC&R document that the county really hangs its hat on was created in 1993. In full disclosure, I made a typo in my materials. The plat was 95, not 93, and I repeated that typo. These CC&Rs from 1993 are what the county is using to deny this property owner free and unrestricted development of their land. And I'm sure you're familiar in the record that originally the record of survey that was created demonstrated 46 lots. However, those 46 lots were not ultimately platted. Attached to HE 1002 is the record of survey, and up in the right-hand corner, lot 45, is the Moshi property. The next page shows the crosshatch moving the Moshi property from the plat of Shamrock Ranch. It's clear this recorded plat excludes the Moshi property. And originally our position was the discrepancy and the ambiguity, the conflict between the recorded plat and the CC&Rs create this discrepancy that requires an interpretation that says free and unrestricted development of land, or look to the declarant's intent, Casey Creever, the declarant who signed the declaration in the record, which I hope you have a copy of, indicating that the Moshi property, lot 45, was excluded, was removed from the subdivision, from the project. The opposition raised in their materials an argument that the ambiguity must be within one document. It's not an appropriate interpretation to take the record of survey, the CC&Rs, the plat, the deed, and determine an ambiguity or a discrepancy based upon the totality of the circumstances. I disagree with that. I think when we're dealing with platting land and we're having CC&Rs that govern subdivisions and subdivision plats, I think you do consider them together, and if there's ambiguity, you still apply the rule that you resolve the ambiguity in favor of free development. But nonetheless, for the purposes of tonight, taking their opposition argument that the ambiguity, the discrepancy must be within one transaction, one document, I want to focus on the CC&Rs, which the county say prohibit this development because they apply. And that language is right out of the order of decision and also the staff report. Where that is factually wrong is on the face of these CC&Rs. I've highlighted on the first page of the covenants, conditions, and restrictions that the Shamrock Ranch development lot numbers initially numbered 1 through 46. The second page of the CC&Rs again references these 46 lots in the middle of the second paragraph. Initially, there being 46 parcels. So it's clear, the CC&Rs govern 46 parcels those 46 parcels don't exist. Mr. Moshi's lot was number 45, and it was taken out. So there are not lots 1 through 46, which is what these CCNRs govern. 45, 46, and numerous other ones were taken out. So it's error. It's wrong to use these CCNRs, which on their face govern lots 1 through 46, when lots 1 through 46 don't exist. Specifically, lot 45 doesn't exist, was never platted. And the county agrees with us. The Moshi lot was never platted. The Moshi lot remains an unplatted parcel. Well, these CCNRs only apply to lots 1 through 46, and if, as the county admits, the Moshi lot is an unplatted parcel, it's not lot 45 anymore. It's not in the development. It's not in the subdivision. And so then it's error to apply the restrictions in the subdivision against lot 45, which was removed. The other document, or the other theory under Idaho law, when you have ambiguity, when you have conflict, when you have a discrepancy, is you look to the party's intent. You look to the declarant. And we have submitted the sworn testimony, the declaration of the declarant, Casey Creever, who says in his July 26th, 2021 declaration that in my capacity as representative of Rocky Mountain Land Company, I intended to exclude the Moshi lot and the 6 other crosshatched parcels from the platting process. This change in intention is visually demonstrated in the record of survey in the final subdivision plat. Well, that's true. It is visually demonstrated in the record of survey. It is visually demonstrated in the subdivision plat. Unfortunately, the contradiction, the ambiguity, the discrepancy, it's still in the legal description in the CCNRs. And that's why we have this dispute here tonight. That's why we have this dispute between the HOA and the property owner. But when you have those conflicting documents, conflicting recorded instruments, we go to the intent of the declarant, and he says, I intended to exclude the Moshi lot from the planning process. So it's out. And the CCNRs only govern the subdivision platted lots 1 through 46, so it shouldn't apply. If it's conflicting or ambiguous because the legal description does cover the land, but the plat doesn't, then that conflicting, ambiguous interpretation is resolved in favor of the lot owner and in favor of the development of the property. Finally, the subdivision, the property has never been subdivided before. That's the county's position. That's unrebutted. It's an unplatted piece of land. Under the CCNRs, no subsequent subdivision of this property shall be less than 9 acres. Well, in order to have a subsequent subdivision, we have to have an initial subdivision, and we've never had that. The declarant, Casey Creever, says he didn't intend to subdivide it. The county says it was never subdivided. It's unplatted. So we have no subsequent subdivision because we don't have an initial one. And so the 9-acre prohibition doesn't apply because this isn't a subsequent application. Some of the neighbors contend that the property owner has waived his objection to being part of the association or being part of the development, when in truth, Mr. Moshi paid for snow plowing and road maintenance. And I have another document here I'd like to put into the record.
HU 1003.
May I approach?
Please. Thank you.
Our legal position is that there was no waiver of his right to assert his position that he is not a member of the association. The association describes their fees in these minutes, which I've marked as an exhibit, that the association is responsible for facilitating the CCNRs and road easement documents, which include maintaining the roads and snow plowing. And Mr. Moshi did contribute to road maintenance and snow plowing because he does benefit from a road easement document. He actually doesn't use the road. His property has frontage directly on the highway, and that's where the access for this development is going to be, directly on the highway. It's going to have absolutely no traffic impact on the neighbors whatsoever. But to be a good neighbor and to be showing good faith as a good neighbor, welcoming, he contributed to the road maintenance and the snow plowing, but he does not want that interpreted as a waiver that he conceded that he was part of the platted subdivision and paid those fees as something other than an easement road maintenance cost. So because the county has readily admitted that it's purely a legal argument and that it's purely based upon the CCNRs, and because the CCNRs govern lots 1 through 46, which do not exist, lot 45 and lot 46 specifically, the Moshi lot were taken out and never platted, we submit that it was error to rely upon the CCNRs to deny the development, and we request that it be reversed. Do you have any questions, Mr. Hearing Examiner?
Yes. So these CCNRs were recorded against or on the Moshi parcel. Is that right?
The legal description, and it's been corrected a couple of times, the legal description, but yes, the legal description still covers the whole 46 lot area of land.
And I'm not sure if you were involved in this part of the process, but when your client acquired the parcel, they did the title search, I'm assuming. And do you know if these CCNRs being attached to the parcel came back on that title report prior to their purchase of the parcel?
I was not involved in that. I do not know based on any personal knowledge about that.
Okay. That's all the questions I have for you now. Thank you.
But I would readily concede, yes, the legal description goes around those boundaries, but the CCNRs are supposed to be for lots 1 through 46, and that's what they say. And we're lot 45 and we're taken out. So that's the real discrepancy there, is the legal versus the CCNR saying it's lots 1 through 46.
Okay, I guess one other question. Do you know when, and apologies if I missed this in my review of the record, when Mr. Moshi acquired the parcel?
2019, January.
January of 2019?
Yes.
So, okay. So let me, 1 second, if I think I have any follow-up questions for you. To your knowledge, has Mr. Moshi initiated any other perhaps legal actions to quiet title or any similar actions on property to maybe have a court suss out this legal question?
That would be the HOA's obligation. I don't think a quiet title action would be appropriate because no one's disputing title or ownership. I think what has typically happened, I used to represent the planning department when I worked for Kootenai County in their civil division. And, in the last 29 years of doing land use law, what typically happens is the HOA initiates a declaratory relief action and asks the court to declare, hey, we want to enforce our CCNRs against this guy. But it's the HOA's burden as the party to the contract to initiate that. I've rarely, if ever, seen the county take that burden on and fight that battle. But no, the applicant here, Mr. Moshi, would not have a quiet title action or anything to assert his rights, because no one's claiming title, no one's contesting title against him.
Okay, thank you.
Thank you.
All right, now we are to the county's case in chief.
Thank you, Mr. Hearing Examiner. It's uncontested at this point that the county staff would have approved this but for this singular issue of the CCNRs. It is also, I believe, uncontested that the land in question is covered by the CCNRs. If you look to your left on the screen, we have a visual of that. So it seems to me that we're really down to the pivotal singular issue of whether the CCNRs apply. I will say that that's a question beyond my ken when it becomes a legal matter. But I can also say that our legal advice from Pat Braden has been that we can't ignore CCNRs in a case like this, because to do so would be setting people up for a legal battle, and that defies good planning practice and common sense. I can back up a little bit and explain why it is that these things come about through a process. I hear Sandy, and we do countless meetings, pre-application meetings with people to explain the process and all the things that are required. And we do our best to give people a sense for the likelihood of something getting through, but we also always say planning is a process. And through the process, we may learn things that may change the outcome of your case. And so it should come as no surprise to anyone in any public process that we go through that things evolve as we learn more. It is also true that we normally don't involve ourselves in civil cases, but again, here we rely on our legal counsel to tell us that he believes these CCNRs do apply. If they apply, in my view, we're foolish to approve something that's creating a problem for people in the future. So in my view, that really is the central issue. We're down to the plain English meaning of the CCNRs and whether you accept what you just heard from Ms. Fulgram or what I suspect you're about to hear from Ms. Simmons. That's all I have unless you have questions for me.
Yes, so did legal counsel provide input on which provision of the code perhaps the CCNR should be applied through? Was that part of your determination to use, I forget which lettered criteria was used?
No, there's not, I would admit, there's not one. Again, I fall back on good planning practice and common sense. I don't want to approve something that's going to cause people to go to court.
Okay. I'm not sure the exact question, but perhaps you could expound a little on the plating process and how a record of survey, perhaps the original record of survey and the CCNRs for the 46 lots was created. From my review of the record, it looks like some of them were peeled off and sold before the plating process was complete. But maybe you could explain a little how the plating process works and what the plating process accomplishes exactly.
Yes, sir. To my right is the planner that handled this case, Amy Hillen. It would be smart for me to turn it over to her at this time because she knows all of these details like the back of her hand.
All right.
Thank you, David. Mr. Hearing Examiner, Amy Hillen, Planner 2. Yes, I did a lot of the research for this this proposal. The record of survey, by our code, a record of survey does not create a parcel. Through my research, this lot, or intended lot 46, remained an unplatted parcel. It was created by means of an exempt division of land. So it was basically a 20-acre parcel, which is still allowed today. You can create a parcel of 20 acres through an exempt land division. And I believe that's how this particular lot was sold. And I believe it was created officially in 1993 by deed. So that's how this one was created and sold prior to Shamrock Ranch 2 being platted. Does that answer your question?
Yes, and I did see that as part of the record. I guess it's difficult to get to the exact question I want to ask here, but maybe you could just in general terms, and perhaps for other people who are part of the public, what the platting process accomplishes. And so a platting process takes a large portion of land and subdivides it into smaller lots, correct?
Correct. And for general knowledge, we enforce subdivision code that we adopted in November of 1995. And so that really started the platting process for us in the county. Prior to that, a parcel of land could be created by deed as long as it met the minimum lot size.
I think that's all the questions I have for you right now. I might end up
Sure.
breaking the order a little bit and coming back if I have some follow-up questions for you.
Certainly your discretion.
All right. Thank you both. And I just realized actually that I did not stop prior to the county's presentation to see if there were any members of the public via Zoom, because I think the only persons here in person are opposed. So if you could really quickly check and see if there's any members of the public who wished to speak in favor of this appeal.
If there's anyone on Zoom that would like to speak at this time in favor, just go ahead and unmute yourself.
Hearing nothing.
I know the property owners, the appellants are on Zoom, but they don't wish to speak.
Okay, great, thank you. So with that, I believe we do have two members of the public who may wish to speak. This will be testimony or evidence in support of the county in opposition to this appeal. So on the top of my list, I have Kristen Hawk, who may wish to speak. Do you wish to speak? And will you come up here and state your name and address for the record? And you have 5 minutes.
My name is Kristen Hawk. I live at 1824 East Teton Road in Athol, Idaho. I'm here to speak of Mr. Moshe, who actually came to our HOA meeting shortly after acquiring the property and did bring up asking if we had any interest in changing our CCNRs from 9 acres to 5. And everybody present did not wish to change or entertain the idea of changing the CCNRs. So clearly, from what I saw from Mr. Moshe, he understood what he bought into. I am not opposed to him breaking into 2 lots, each lot 10 acres or 11 acres and 9 acres, but we all maintain that 9-acre parcel in our community. Yes, outside of the community, people have 5 acres. But inside, we maintain that. Most of us have animals, and we enjoy having that space and that property. And I understand they're saying that our roads won't be affected because it's breaking out onto the 54, but that is never the case. We all know that people like their toys. They like to use the roads. They're going to be coming in, and those roads are going to be used. And there doesn't change from somebody who buys that end lot to break through into the private road later on. So my concern is Mr. Moshi knew what he was purchasing. He made that clear at our HOA meeting that he attended. He talked to members of the community. We all were against changing the CCNRs to 5-acre lots. And so I feel as though he is coming about this way, trying to find a loophole to go around what he agreed to originally. And I do appreciate the original denial, and I do hope that you will uphold that denial. Thank you.
Thank you. And Carson Hundrup may wish to speak.
My name is Carson Hundrup. I live at 1637 East Shoshone Ave in Athol, Idaho. I too am opposed to this, and like Kristen said, this subdivision is a lot of 10-acre, all 10-acre parcels. And when they said that this lot is not compatible because it doesn't apply with the other 10-acre parcels, there's more than one subdivision in our area. There's another subdivision to the west, then there's another one or two subdivisions to the south that were all part of a break off of that Remington Ranch. And those are all 10-acre parcels. I don't have the exact number of lots, but there's more than just our 46. There's, at least 2 other or 3 other phases that are all 10 acres, both to the north and south of Remington Road and to the east of Clagstone. So there's a lot of lots in there that are all 10-acre lots, and I know that there are a lot of 5-acre lots. Pretty much all the land up there is being eaten up into 5-acre lots. I work for a construction company, and we're doing some of that work too. But to keep these at 10-acre lots is what has appealed to everybody living in that area. We like the 10-acre lots. We'd like to keep it that way. I'm not aware of the intended exclusion of the Moshi lot. That's news to me. But I know that with all of those other lots around there, it's kind of hard to believe that they would just take one lot and take it out. And as far as platting a lot, you can plat a lot, and I may be wrong in this, but I believe you can plat a lot, but even though the lot may have been platted before this subdivision, doesn't mean that it can't be included in the subdivision, just because it was platted and taken out before the major subdivision. So I don't know what kind of legal status there is there, but anyway, we'd like to keep it at 10 acres. And like Kristen said as well, there's at least 2 lots that would also have potential access into Teton. I know if I were to buy a lot in there, I would want to have access into 41 or onto 554 and also to the south. So there's nothing that's going to stop at least 2 of those lots accessing onto our private roads. And so that would just help to greatly increase the traffic on our private roads, which we would have to be paying for and which they potentially would not. So, thank you.
Thank you. All right, this is an opportunity for the appellant to have a rebuttal period. If there are any points that were brought up by members of the public. Oh, I'm sorry. Again, I missed the members of the Zoom again.
There may be members on Zoom that want to speak on the county's behalf. There are 2 attorneys from Winston-Salem.
Of course.
Know if they want to say anything.
Of course. I don't have my screen with the Zoom up to remind me that there are people on Zoom watching this.
So,
Yes, you are correct.
If you have an interest, now would be the time. Just unmute yourself and let me know.
Your mic might not be on anymore.
Yeah,
Okay.
my cohort turned my mic off a minute ago. That's my fault. Casey or Dalton, if you would like to speak, now would be your time.
Thank you. I will be speaking on behalf of the Ponderay Ranch Owners Association. My name is Casey Simmons, and my address is 250 Northwest Boulevard, Suite 206, here in Coeur d'Alene, Idaho. For the most part, the Ponderay Ranch Owners Association would like to submit its argument on the letter that was tendered to the hearing examiner as well as the brief. However, I would like to highlight some of the points of the brief, given that, Mr. Hearing Examiner, you have just received that document tonight. One of the main arguments by Mr. Moshe and his attorney is that there are these ambiguities, these alleged ambiguities for the various documents that involve the Moshe property. And one of the documents that is mentioned is the CC&Rs. One of the documents that's mentioned is the final plat, which was recorded on June 14th of 1995. I think it's important to give a brief timeline of when all of these documents came to being. On March 22nd, 1993 was when the original record of survey was recorded that had the 46 lots and had the legal description, which included the Moshe lot. On May 14th, 1993, the CC&Rs were recorded, which again spoke of 46 lots and included a legal description that includes the Moshe lot. On October 28th, 1993, the Moshe lot was sold via warranty deed by the developer, and in that warranty deed, which I believe was an exhibit to the original application, or I'm sorry, the original hearing, that property was purchased subject to the CC&Rs. And then, of course, June 14th, 1995, the final plat was recorded, which crosshatched the Moshe lot. However, what's important to remember is what platting does and the fact that it is a separate transaction from adopting restrictive covenants. Platting is essentially how describes how a tract of land is divided into lots in a county. And the briefing that we submitted talks about that a plat must accurately describe and set forth all the streets, easements, public grounds, blocks, lots, and other essential information. And that is the Kepler-Fleener case at 152 Idaho at 211. Idaho case law specifically states that platting real property and adopting restrictive covenants are two separate transactions. That's pursuant to the Birdwood Subdivision Homeowners Association, Inc. versus Bellotti Construction, Inc. at 145 Idaho 21, 2007 case. So what we are looking at is was the Moshe lot bound by the CC&Rs when the CC&Rs were recorded on May 14th, 1993. And we agree with the county and with Mr. Braden that the CC&Rs that were recorded clearly indicate that the Moshe lot was included in the CC&Rs. And to further bolster that argument, we have a warranty deed that was recorded less than 6 months later that specifically said that lot was being sold subject to the CC&Rs. There is case law that indicates that a homeowner can, in fact, bind real property to CC&Rs, and that is exactly what happened here. We are the Homeowners Association is respectfully requesting that Mr. Hearing Officer, that you uphold the county's decision to not allow this subdivision to go forward. I think it speaks highly that out of it looks like 19 comments that were submitted for this appeal, there was one neutral comment, two supporting comments, one by Mr. Moshe and one by his counsel. And then there were 16 opposing comments. And in reviewing those comments, the other homeowners are vehemently against and are pretty articulate in why they are vehemently against such a subdivision. We ask that Mr. Hearing Officer, that you do not find that there are any ambiguities. Ms. Fulgham talks about the statement of the former developer. However, parole evidence, looking outside the four corners of a document, only comes into play when it's ambiguous. There are no ambiguities in these documents. And in the CCNRs, it specifically states which properties which properties it covers. And it also specifically says that lots shall be no less than 9 acres. So we do ask that, Mr. Hearing Examiner, you follow the county's recommendations, that you uphold their decision to reject the minor subdivision proposed by Mr. Moshi. Thank you.
Thank you. Is there anyone else on Zoom who wishes to enter testimony at this time?
I would like to, please.
Go ahead and state your name and address for the record, please.
My name is Nicole Hundrup, and I live at 1637 East Shoshone Avenue, Apple, Idaho. My biggest concern that was brought up about this not affecting the people in the area is how much it would actually affect us. I was at the meeting in 2019 that Mr. Moshi had been at as well, and he specifically brought up punch-through properties where the property would go through from 54 to Teton. And that is a huge concern for us because as a community that has a lot of people that are low income, trying to maintain the private road as it is has been difficult. And so not only would these 4 potential new properties, I mean, what would stop them from connecting to Teton? Because that property, Mr. Moshi's property, actually goes to the middle of Teton. All of our properties in the subdivision, our property lines go to the middle of the private road. So there's nothing stopping a new person who's purchasing several of those lots to connect into Teton. And then there's really nice and easy access now from 54 through those properties to Teton for people to cut through to get to Remington or south from there. He's already done quite a bit of work with the road. I'm not quite sure if there's permits pulled for those or not. We could not find them, but it's a very nice looking road that I can see people very easily cutting through our neighborhood. And that really, really does affect us because we have a hard enough time trying to keep up on the road as it is. Thank you so much for the original decision, and thank you guys so much for your time. I really appreciate it. Thank you.
Thank you.
Anyone else at this time would like to speak on Zoom?
All right, hearing no other members of the public, we'll allow appellants their final rebuttal. And I do ask you kindly keep it to approximately 15 minutes.
I'll be brief. This is Sandy Young, again for the record. I would just like to address the 2 concerns I heard from 2 opponents about the access. The county does a really great job of adhering to, or having an applicant adhere to the plat or the site plan as it's proposed in the application. So any concerns about access from the southern 2 lots using any roadway to the south, Teton or any of the others, wouldn't be allowed. Access, as shown on the plat that Mr. Moshi has proposed, is that all 4 lots will access directly onto Highway 54. He has obtained a permit from ITD for that approach, and the county as well could make that a condition of approval. Let's see. Oh, and then I heard one other comment from the gentleman that's present about he wasn't sure how the property was platted previously since it wasn't included on this plat. I just want to clarify for the record, it is unplatted property. It is a what we call an aliquot parts description of land, and so it has never been platted, to Miss Fulgham's comment about the fact that this that whole subsequent platting question issue brought up would not apply to this parcel. And that's all I have. Thank you.
Thank you, Mr. Herring, Examiner. I have a copy of the title report that I want to put into the record. I think it's in the lowercase proceeding, but I'll add it because I want to talk about it here. Hearing Examiner 1005. And I've tabbed a key document here from the prior owner, Barbara Gallagher. And this document in the title report specifically states that I'm questioning if the CCNRs supposedly attached to the acreage I recently purchased are correct. It's been brought to my attention by both the county planner and a civil engineer that the CCNRs may not attach to my unplatted parcel because my parcel may not be within the subdivision as stated in my escrow. In Mr. Callahan's comments, he talked about, Pat Braden, the county attorney, said such and such, but Pat Braden's not here. His comments aren't in the record. There's no statement, there's no report, there's no legal analysis. There's nothing to go on as to whether he said that, why he said that, and what his analysis was, if anything. You ask 3 lawyers a question, you could get 3 different legal opinions quite easily. And this question about this title report and the previous owner raising it with the county and a differing legal opinion is not unusual. That's not unique in real estate law. I submit that it's not appropriate to deny a property owner a application for his land based upon, well, our legal counsel told us this. Well, where is it? Where's that in the record? How do I rebut that? How do I address that? How do I have notice and the opportunity to respond when he's not here and I don't know what he said or when or how he said it? In regards to the statements from the HOA attorney, it's true in 1993, the documents indicated this was going to be a 46 lot subdivision, but it wasn't. And when it became a 38 lot subdivision, and when it cut out the Moshi parcel in 1995, everything changed. Had the plat in 1995 not excluded the Moshi parcel, then I would submit counsel's right. The 1993 documents are unambiguous and they govern the full legally described area of 46 lots. But everything changed on June 14th, 1995, when the plat was recorded, and there were not 46 lots, and there were not the Moshi property or the other 8 parcels in there. Another objection to what opposing counsel stated was that homeowners can bind their land to CCNRs. No, these CCNRs were recorded and bound the land by the declarant, Rocky Mountain Land Company, Casey Creever. Nobody can bind anyone else's land. And Casey Creever the declarant, the Rocky Mountain Land Company, said, no, I did not intend to bind the Moshi lot. I excluded that lot from this subdivision. That's what the crosshatch in 1995 represented. Finally, you cannot have an unplatted lot in a subdivision. The very definition of a subdivision is a division of land creating smaller legal parcels. A division of land. An unplatted parcel, which is what the Moshi lot is mutually exclusive from a subdivision. So because the record is unrebutted, because it's undisputed, the Moshi parcel is an unplatted, undivided property. It is not in the subdivision. And because the CC&Rs, unfortunately, back in 1993, referenced lots 1 through 46, and when the plat was recorded in 1995, there were only 38 lots. There is an ambiguity. There is a contradiction in those CC&Rs because they govern lots 1 through 46, and lots 1 through 46 don't exist. There's only 38 lots. So how can you possibly have and rely upon CC&Rs, which on their face say they apply to the subdivided lots 1 through 46, when you only have 38? It's a contradiction. It's inconsistent. It's an ambiguity. And based on that ambiguity, we go to the declarant's intent and we go to the free and unrestricted development of land. Because it's unplatted, it's not a subsequent subdivision, and so the 9-acre prohibition doesn't apply. Are there any questions? Any other areas?
I have no more questions for you.
Thank you, sir.
Thank you. And as I have no other questions for any of the other parties present, that will conclude tonight's hearing. So with that, I will close out the public hearing for Appeal 21-0003 at 7:04 p.m.
Thank you, everyone.
Thank you.